Welcome to the Chaos Sector. We return to the Matrix. If a suspect's DNA was allegedly discovered on a knife sheath in a murder investigation, and law enforcement used technology to obtain the identity of the person's DNA, but never disclosed the process of obtaining that DNA, does this eliminate the evidence the DNA of the suspect was on the knife sheath? Well, despite what illegal process law enforcement used to obtain that DNA, it still exists at the scene of the crime. That's the focus in this episode: what direction the defense should be taking against the prosecution. Let's get started.
Now to the Idaho College murders case. The judge is set to issue a ruling on DNA evidence that prosecutors say ties Brian Kohberger to the murder scene. Kana Whitworth has that story for us. Good morning, Kana.
Yeah, Robin, good morning to you. So ahead of some pivotal hearings later this week, Brian Kohberger's lawyers are arguing that the DNA evidence against their client was gathered illegally and say that it should not be presented to a jury in a death penalty case. They also want the arguments surrounding it to be made public. This morning, Brian Kohberger's defense team trying to get critical evidence thrown out as they raise questions about how law enforcement zeroed in on him. His attorneys taking aim at DNA analysis known as investigative genetic genealogy, a process that involves entering DNA profiles into public databases to find relatives and narrow the list of potential suspects. Prosecutors tying Kohberger to the quadruple murders after they say his DNA was found on a button snap of a knife sheath found at the scene.
The argument for the defense as to why the DNA should be thrown out is less about the result pointing to Brian Kohberger, but more about the science.
Wait, this is problematic. If Ann Taylor is claiming that the process of how the prosecution obtained Kohberger's DNA was illegal, more so than if his DNA was physically in the home, this essentially is conceding he is guilty of those murders. Now, some may say, well, she's strategically dissecting the prosecution's case by exposing how they illegally obtained her client's DNA. But this is, let's continue with it first, and then we'll give our take.
It was mid-November 2022 when prosecutors say Kohberger, a former PhD student, entered an off-campus apartment and fatally stabbed Kaylee Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin. A not guilty plea has been entered on his behalf. Kohberger's attorneys now filing a petition to unseal evidence and make hearings public to combat what they say is an overwhelming public sentiment of his guilt. Now, overnight, we did learn that much of Thursday and Friday's hearings will, in fact, be private. Parts of it will be live streamed, but we're told the courtroom will remain closed even to family. And Kaylee Gonsalves' father telling me the family spent some $5,000 to make their way to Boise for these hearings. And as he puts it, Rebecca, he'll now be forced to watch justice unfold from the courthouse steps.
So many twists and turns for those families who've already been through so much. Okay, Kana, thank you.
Okay, this is not what Ann Taylor should be focusing on, because it's a revolving door. The prosecution will stall this out, and to be honest, it doesn't refute the physical evidence of Kohberger's DNA found on the knife sheath, you see. Arguing about the IgG process, and if it was illegally obtained, is not, I repeat, is not, refuting the actual DNA found in the home. It basically becomes semantics by the defense, and this is what the judge is challenging Taylor about. What Taylor should be focusing on, since she's addressing how they zoned in on Kohberger, is why was WSU campus police searching for a white Hyundai Elantra on November 29th before any specific vehicle was identified, you see. Keep in mind, the defense is defending from the stance of Kohberger being framed, but Taylor is not willing to articulate this in the trial. And because she is not hitting the prosecution directly with this, the judge and jury will only focus on the DNA discovered in the home. We left a comment on Jules' recent video discussing the very issue. Quote, "She is not going to sway the judge and jury regarding the DNA. It's the key to the frame. You have to work around the DNA to prove the DNA was planted. Because the judge is only focused on what evidence is being presented, that will either convict or acquit the defendant. At this point, they have DNA of the defendant inside the home. Taylor going back and forth about how they determined it was his DNA is a losing battle. Instead, demand that the prosecution provide the defense with footage from 1112 King Road, which is the neighbor's security camera. If Kohberger is never seen entering the neighborhood, then this means he was never there. Then you can work backwards to challenge the DNA in the home." Unquote. You see, to challenge the claim that Kohberger's DNA was inside the home, demand that the prosecution provide surveillance footage that places him in the neighborhood. To leave that DNA inside the home. If they can't produce it, then he wasn't there, which obviously proves the DNA was used to frame him for the murders. And of course, there's nowhere for the prosecution to hide. They won't be able to explain how Kohberger's DNA ended up at the scene of a crime when he was never there. Talk about a nationally covered frame job for everyone to see, right? It's the surveillance footage from the next door neighbor's home that would either sentence Koberger to death or have a Rolodex of lawsuits lined up, with the biggest takeaway from it all being that the killers are still out there, and everyone involved in framing Koberger seemed quite fine with protecting those killers to frame an innocent man for it. But Ann Taylor continues to question how they obtained the DNA, which was found at the crime scene. You're not effectively defending your client, because it doesn't challenge the existence of the DNA. It challenges how they obtained the DNA that exists there, you see? And the judge will continue to resist these efforts and point out that the DNA was discovered at the home, and this justifies probable cause for arrest and charge. That's all that matters, is the evidence. You can question why the additional males and their DNA being discovered wasn't investigated or identified. You can even challenge Dylan's conflicting accounts. These are all strategic attacks, but once again, it doesn't take Koberger out of the picture, based on his DNA, claimed to be discovered in the victim's bedroom. You have to expose the frame by way of demanding surveillance footage be presented, and I mean immediately, because everything else does not exonerate Koberger, despite there being shady business in the investigation from the judge and jury's perspective. Koberger not being spotted in that neighborhood at any point exonerates him. Simple. They can claim that Koberger's vehicle was spotted in the neighborhood as supporting evidence for a probable cause as well. But with this claim, they would have to physically prove Koberger's vehicle was in the neighborhood. And sure enough, they seem to have a problem showing this. Mind you, they never released any surveillance footage from the neighbor's security camera, even before they had Koberger as the suspect. So this means they didn't want the public to view the surveillance during that time frame of their investigation, but simultaneously wanted the public's help in keeping an eye out for a vehicle they identified in that surveillance. This is not how law enforcement goes about an investigation, my friends. If there is anything or anyone associated with surveillance where a crime was committed, law enforcement is releasing that footage to the media. The reason for this, as we pointed out, is to do exactly what? Inform the public about the potential danger that exists out in society. It is their public servant duty to make sure they're doing their part to inform citizens of potential dangers. They would never conceal surveillance footage unless it's graphic. But even then, law enforcement releases graphic video, which displays violence anyway. So just showing a vehicle driving in a neighborhood should be quite easy to do, right? Unless there is something that compromises or contradicts the arrest and charge against the alleged suspect. Again, Batman claimed he was searching for white Hyundai Elantras around December 10th, after the December 7th press release of the make and model, right? But as we know, this is all bogus. WSU campus police obtained a make, model, and color of a vehicle on November 29th. Yet how could they have a specific vehicle if Moscow PD hadn't identified the vehicle until December 7th? Rhetorical, of course. But this is what Ann Taylor should be exposing, because it's proving her client was framed. For WSU campus police to be searching for a specific vehicle November 29th, approximately 2 weeks prior to a specific vehicle identified, this means they already had a specific vehicle. But where did they get the specific vehicle from? Moscow PD didn't have it yet, so what source gave WSU campus police this vehicle? Well, it appears to be, that's right, Batman.
Now please think deeper here. Again, WSU campus police identified Koberger's Elantra on November 29th, and this vehicle was then given to Moscow PD. Moscow PD actually visited Pullman, Washington, and obtained surveillance footage from his apartments. Now this was never reported in the mainstream media, nor was it in the PCA. Why? Because if it were to be, this would mean someone had to have specifically spotted a white Hyundai Elantra leaving the scene of the crime. Not by surveillance, negative. An eyewitness, because at the time, Moscow PD reported, based on the surveillance they examined, it was described as a light-colored vehicle. It was only until the so-called FBI expert identified a 2011 to 2013 white Hyundai Elantra was when Moscow PD sent out their press release of this vehicle December 7th. This indicates that within that first week or so in the month of December, the vehicle was identified as a white Hyundai Elantra. So based on the public information and investigation, November 29th's identification of a vehicle is fucking impossible. And of course, Batman submitted Koberger's vehicle on December 10th. But we know that he is likely the source of pointing law enforcement in Koberger's direction. And the FBI is slithering around in the shadows, organizing the frame through the investigation. Mind you, a former FBI agent stated that they were tracking Koberger and had state officers set up to stage traffic stops to, quote, inspect his vehicle and if he had any visible cuts or bruises on his hands. They denied this covert operation, but one of their own snitched. The reason they denied this covert operation, again, as we've pointed out in our investigation, is if the FBI was found out that they were tracking Koberger, then he should have been brought in for questioning. This is not a violation of his rights. His vehicle matches the description of a person of interest, or an alleged killer. Now, of course, they can't pull every white Hyundai Elantra over and question them. But since you're tracking him anyway, might as well bring him in for questioning. They didn't, because Koberger was being not only tracked, but simultaneously was being framed. Tracked him all the way to his parents' home in Pennsylvania, snooped around and rummaged through his trash, obtained his father's DNA, then used that DNA and planted it on a planted knife sheath in Madison's bedroom. Of course, this is why the IgG processing is being covered up by the prosecution, because there is no direct DNA of Koberger on the knife sheath, it's DNA of his father. And if that were to be exposed, then the frame would be blown out of the water. Over and over again, we've done this. The buccal swab they obtained from Koberger was after they had already framed him with the DNA at the crime scene. It was simply to make it appear that Koberger's DNA was, quote, professionally and lawfully being processed. The amount of DNA left behind is bogus. Meanwhile, they have a whole bucket of DNA of blood from another male suspect inside the home that's still roaming around out there in society. Taylor attacks this, which is in fact a great attack against the prosecution. But the judge is hardwired to contest that Koberger's DNA was discovered on a knife sheath in one of the victim's bedroom. This will be more difficult to the defense than just requesting surveillance footage from the neighbor's camera the night of the murders. The prosecution has it, Moscow PD has it, the FBI has it. It's a part of the investigation, it's ruled visual evidence. Well, time to show the judge and jury what unfolded that night. They won't, because they can't. In fact, they won't prove how they utilized the IgG process to the defense, neither. At least voluntarily, the judge would have to pull their teeth to provide this to Taylor. That traffic stop was December 15th. December 7th, Moscow PD sends out a press release for a 2011 to 2013 white Hyundai Elantra. December 10th, Batman submits Koberger's vehicle to Moscow PD. Now again, he is in Pullman, alleged to stay 1,200 feet from Koberger's doorstep. Oh, okay. December 15th. Koberger is being tracked by the FBI. That's 8 days. But the key to this is the November 29th search for a white Hyundai Elantra, which WSU campus police identified Koberger's vehicle in his apartments. Now, how in the hell are they searching for this vehicle before even the so-called FBI expert identified this specific vehicle in surveillance? The only way this is possible is somehow WSU campus police obtained information about the suspect's vehicle before Moscow PD did. This would mean someone in Pullman knew that the white Hyundai Elantra was involved in the murders. Yep, that's the fuckery we're talking about. There is a middleman snooping around, and that middleman would be Batman. And we have to include Bonnie as well, because she frequented between that trio of states, being Oregon, Washington, and Idaho, with her partner in crime Clyde. She was also arrested in Pullman, which for some reason, Pullman coincidentally released their body cam footage during the time of this investigation. In that footage, she is spotted reaching in her ass crack, taking drugs out, and dumping them in the trash bin. We spotted it, thought she was slick, not slick enough, you need more WD-40. Even WSU Kim is a suspicious character, because she stated she called the FBI later that day. Again, WSU Kim called the FBI that same day, I repeat, that same day. So are we to believe that no other parents of college students in Idaho felt a similar concern to call the FBI about what they know? Oh, it would be a parent from the same town that Koberger resided in. Oh, okay. As we pointed out, this was a frame of Koberger by a criminal network, and people who conspired with that criminal network to protect, well, the criminal network.
Batman's vehicle was never identified. Heck, the DoorDash driver's vehicle was never identified. Who knows what vehicles these individuals were using? Some claim Batman drove a white pickup truck. Yeah, but nobody can confirm these claims unless you physically see that truck picking the girls up and dropping them off back home. Again, we would see this if they released the security footage from the neighbor's home. among other things.
Since everyone is so eager to leak footage out there, why hasn't there been any surveillance footage showing them arriving back home? Come to think about it, let's touch on this for a moment. There has been footage released from the grub truck of Kaylee and Madison. There has been footage released of them walking with Jack Showalter, and the mainstream media depicted him as a potential suspect early on, remember? Yet they never reported on what Jack meant by telling Madison, quote, "They're gonna get you for this, Maddie," unquote. Mind you, they examined that audio because they pointed out that Madison, quote, "told Adam everything," unquote. But this is in relation to what Jack warned her about. And yet they never inquired about this warning? Now that's the mainstream media. Of course they will cherry pick to push a narrative. But Moscow PD, you see, they never investigated this warning and even went on to clear Jack Showalter. If there was a warning to Madison, and this ends up being one of the victims later on, where the hell is the investigation into what that warning was about? Rhetorical. They interrogated Jack, found out who was involved in the murders, and covered it all up. We went over this relentlessly. Then you have all the body cam footage from the victim's home prior to the murders. You even have body cam footage of Koberger's traffic stops. A bunch of social media videos of the victims dumped out there, and the dreaded Linda Lane surveillance was even dumped out there. But the most important footage from 1112 King Road, which determines who was in that neighborhood before, during, and after the murders, this footage has somehow not made its way to social media. Yet a leaked snapshot of the surveillance at 1:56 a.m. made its way there. Again, put this all together. Jack's warning to Madison was never addressed by the mainstream media, such as Witches Nancy Disgrace or Ashley Batfield. Moscow PD nor the FBI publicly mentioned anything about it. No investigation into the obvious consequence or even danger that Madison would face due to what she told Adam. Surveillance footage was obtained the next day from the neighbors, yet nothing was released to the media regarding any potential person of interest spotted in the neighborhood during the time of the murders. Heck, they even obtained the Linda Lane surveillance the next day, but as we all know, it was not, I repeat, it was not Moscow PD who released that footage. But mainstream media and Moscow PD would map out the time frame of when the victims left point A, arrived at point B, who they were with that night, zooming in on individuals in the grub truck surveillance, questioning if they were potential suspects. I mean, come on. Detectives are spotted snooping around near the fire hydrant, where they discovered the black coat that Madison was wearing the prior night, pulled what looked like a weapon out of it, then threw the coat back onto the ground. Again, we point this out. Detectives didn't stumble upon that area, they were led to that area, meaning they knew that the black coat Madison wore that night was there. Who told them? Well, we don't know, but clearly they were directed to that evidence trail, and flat out concealed crucial evidence to the murder investigation. DNA more than likely was on that coat, perhaps blood, and whatever they pulled out of the coat, which appeared to be some sort of weapon, also had DNA on it. The point here, Ann Taylor should focus on that very 1112 King Road surveillance footage, because it determines everything, you see? It's do or die. The DNA is actually not what will convict Koberger in this dynamic, because you have to prove Koberger was physically there. The burden of proof falls on the prosecution to prove Koberger was there. Now the judge may challenge this and state his DNA was discovered in the home, and that's already been proven. Therefore, there is no burden of proof for the prosecution. But again, this makes focusing on the surveillance footage that much more important. If Taylor demands that the prosecution provide this surveillance, and they somehow fail to provide it, then a burden of proof is introduced to prove that Koberger was physically there, despite, that's right, despite his DNA allegedly being there, you understand? Taylor has to demand this footage be provided, regardless if that portion of the hearing will not be accessible for public viewing. If she motions to the judge that she needs to view the surveillance footage from that neighbor's camera, and it doesn't show Koberger's vehicle, then he is not physically there. That literally destroys the prosecution's case. Some may refute this in saying the prosecution does not have to provide this surveillance. Well, if you're claiming the defendant was there, you claimed he was even there 12 times prior, which indicates he stalked those housemates. Yet there is no proof of it. And there hasn't been any surveillance footage from that camera released, but a screenshot leaked. The DNA being the key evidence starts to become weaker. It determines Koberger's fate more than the DNA, you see?
Exactly, stay on the neighbor's camera because they're trying to slip that Linda Lane surveillance into the equation. Yep, we see it coming. That's why it was leaked, which was about a year later. Now, even though Taylor can challenge that surveillance in saying it doesn't identify Koberger's vehicle specifically, it's during the time frame the murders occurred, and it aligns with the so-called behavior of the suspect's vehicle. that being Koberger. You can't risk the prosecution throwing that surveillance out there, because although it's not conclusive, it is displaying what appears to be a white vehicle, and its behavior is suspicious during the time frame the murders occurred. This is extremely dangerous footage because of the eerie behavior of the vehicle in association to the murders. And if so-called car gurus such as Get a Clue were to outline the vehicle as being a Hyundai Elantra, surely other vehicle experts would display this in trial. You know, like the so-called FBI expert who identified a 2011 to 2013 model. Keep in mind, Gray Hughes literally went on national television and claimed it was Koberger's vehicle in that Linda Lane surveillance. So to eliminate the possibility of the judge and jury being convinced that's Koberger's vehicle, demand the prosecution provide the surveillance footage from a previous location, which displays the entrance into the neighborhood. That's it. Nothing can be avoided, distorted by trees, gates, or any other type of obstruction. It's clear to see which vehicle enters the neighborhood, what time, what color or color tone of the vehicle, and what activity occurs after that entrance. Going back and forth about how the prosecution obtained Koberger's DNA only leads to Taylor getting into a semantics argument with the judge. And trust me, she will not win that argument. What happens as a result? The judge starts to lean towards the prosecution, with DNA being the core evidence, and the defense starts to appear as if they have no real defense, other than some violations or illegal activity committed in the investigation. This does not eliminate the evidence the prosecution is presenting. This is why we presented the initial scenario in the beginning of the episode. The more Taylor focuses on the IgG process, the more Koberger looks like he was the killer. And Taylor is only trying to criticize the prosecution on how they went about proving Koberger was the killer. You see, that does not help him whatsoever. Again, the suspicious behavior, the snooping around, even the additional male's DNA discovered, Dylan's conflicting accounts. All of this is pushed to the side because the defense would not prove that Koberger wasn't physically there. You have to prove he wasn't there. If you claim that Koberger did not know the victims, you are claiming he was framed, right? So, continue drilling this into the judge and jury's minds, but not by focusing all of your energy on the IgG process. It doesn't take the DNA out of the home. Focus on the physical, or better yet, the visual evidence of who is in the neighborhood when the murders occurred. If we were to see that footage, we know who would be physically seen without a doubt. Batman and Bonnie, which would be the so-called private driver and the DoorDash driver. These vehicles would be spotted at the reported timeframes they were there. I guess this is another reason the neighbor's camera footage hasn't been released. It's imperative that this footage be displayed in trial. Otherwise, the prosecution is not required to provide physical evidence of the suspect's presence in the neighborhood. That needs to be proven, and if they can't prove it in court, then the dominoes start falling very fast. Because now you have physical evidence that someone else is responsible for those murders. And from there, a whole new investigation is forced to take place.
Good take. Let's make sure everyone understands what we're saying here. It's not that the focus on the DNA by way of the IgG isn't important. To the contrary, Taylor should be attacking it. It places Koberger inside the victim's home, specifically in one of the victim's bedrooms. But the problem with focusing on the DNA, at this point in the case, is the judge has already established a point of contention, meaning they are only interested in facts or evidence. And the so-called facts and evidence has Koberger's DNA collected from a knife sheath inside the home. Taylor cannot, I repeat, Taylor cannot refute this evidence head-on. She has to work around it, because the prosecution isn't burdened with, burden of proof. The DNA of the defendant was discovered at the crime scene, and regardless of the process, the prosecution is claiming the DNA was found. Taylor demanding the prosecution to show how they obtained it. Well, it's effective, but not in guaranteed angle that would prove Koberger was framed, you see. What if they provided the IgG documentation showing the procedure, which resulted in a match with Koberger's DNA? Then what would Taylor defend against at that point? It would not help Koberger whatsoever. And I would suggest the prosecution actually wants her to focus more on the DNA, because it allows them to keep dragging their feet with a sense of confidence, as the DNA is in fact evidence against the defendant. Let me elaborate, you see. The DNA places Koberger in the home, regardless of how they got it. It's based on what was collected, wait for it, at the victim's home. Unless she is challenging the actual DNA at the home, it will become quite difficult. You understand? If Taylor states in the hearing, quote, "We have confidence that the DNA collected at the scene of the crime is not Mr. Koberger's, and the reason the IgG process is so important is because we believe the FBI collected his father's DNA, which was collected in Pennsylvania, and then placed that DNA at the crime scene, then ultimately ran it through IgG to find a match, unquote. Now that is how you attack the DNA. Just come right out and state he was framed. Stop being nice in this trial, because they're definitely not being nice. They're trying to sentence your client to death. But to truly blow everything up, demand the prosecution provide the defense and the court with the surveillance footage from the neighbor's camera. It will show everything. That is the greatest evidence in the case, my friends. Now, on a side note, everyone is talking about Bethany's alleged accounts of seeing a naked man running out of the house with clothes. Of course, there were speculations in the past about this. Apparently, it's been submitted as evidence in the trial. Well, this has to be the exculpatory evidence she has, right? This is why her attorney convinced her to not meet with the defense, because her accounts are totally different from Dylan's. The preliminary hearings were shut down, and the defense was not allowed to challenge any of the alleged evidence against Koberger. Remember, Bethany agreed, I repeat. Bethany agreed to meet with the defense, who claims she has exculpatory evidence that will exonerate Koberger of all charges. Bethany was willing to meet with the defense, which we could assume, get this, she would basically testify in favor of Koberger in the preliminary hearings. Who knows where this case would be if that ever happened, right? Also, we know some have disputed the claim about Dylan in the sorority, but we came to the conclusion that Dylan was not a Pi Beta Phi, like Bethany was. There was a distinction between the two in the article, stating that Bethany was in the same sorority as Xana and Madison. It never stated that both Bethany and Dylan were in the same sorority as Xana and Madison. It separated the two survivors there, and it's fitting, because they were not actually paired together as survivors. In our analysis, one was a conspirator, and the other was caught in the middle of mayhem. Dylan was not a part of the sorority. We came to the conclusion that she was posing. This was done intentionally, of course, in attempts to create no effective way to challenge a guilty verdict. Although Koberger has pled not guilty by what the prosecution claims, his DNA was found on a murder weapon accessory. Mind you, Bethany's affidavit, well, it's vague. It doesn't claim she heard anything, no timeline, no interaction with anyone. The only thing that apparently was reported that she observed was some naked man running out of the house. Now, the mainstream media and so-called criminal psychologists and those dreaded so-called former FBI agents all suggested that this was the actions of Koberger, because he was studying criminology. Remember the claim he bought a Myers jumpsuit? Yeah, see, that naked man was transformed to Koberger, using that suspect's actions and placed them onto Koberger to fit the mastermind narrative. But as we've pointed out, why would Koberger go out of his way to so-called carry out the perfect crime by not leaving any evidence behind, yet drive a light bulb at night? Really, just gonna go murder these college students in my light bulb? Never mind that everyone in the neighborhood would easily spot it, especially all cameras in the area. Or it's like reverse psychology, right? He's driving a vehicle so bright that it's actually invisible at night. Oh, okay, I get it. Not too smart for someone deemed to be a mastermind. Oh, but they allude to him being a mastermind by claiming he turned his phone off when it was time to commit the crimes, and the reason there wasn't any concrete evidence in his vehicle nor on his body is because he came with a, quote, kill kit, which he threw everything into a garbage bag before getting back into his light bulb. Oh, okay, he was that intelligent, but not intelligent enough to cloak himself in the darkness by driving a darker vehicle. I guess the risk of being a driving bullseye for eyes and cameras was too tempting. It would be best to drive a darker vehicle at night, you know, makes it extremely difficult to identify in surveillance. But I guess not. Then, of course, you had the lack of motive established. I guess this was a part of his mastermind thought process as well, because there is no evidence he stalked anyone. But Koberger wasn't in Pullman that long, if not mistaken. Someone can correct the chaos on this, but wasn't he in Pullman for only 6 months to a year? So within this time frame, he spotted those housemates somewhere. And despite his goals in life, they overwhelmed him with this twisted obsession, which there is no evidence of it. But it has to be, based on a motive to travel specifically to Moscow, specifically to that neighborhood, specifically to that home, and commit those murders. Where is the connection? There has to be something out there, right? Surely the serial stalker left something behind. A photo he just couldn't delete from his laptop, heck. a photo he has saved as his screensaver on his cell phone. There would be something that acts as a trigger for a stalker, linked to their targets. Well, he's a new type of stalker, I guess, where he has no connection to his target, not even a single photo on any of his devices. Wow. And what about the time frame? How would Koberger know the housemates were home? How would he even know who was all inside the home? What if they had a party? What if there were even more people there, spending a night? He would have to be stalking someone in the home, or get this, have eyes on the inside, notifying him when to arrive. But it still doesn't add up even with an insider, because that house is a bit random when it comes to social activities. Didn't Dylan claim she thought there was a party going on? Although she was lying, it paints the picture of the home holding parties at all times in the night. You had 6 people in the home, and since there's no other reason other than a targeted attack, then Koberger would have balls of steel to enter. You know what we've been over this. It's exhausting. The prosecution tried to break Koberger with the planted DNA, which we can suggest was not even physically planted inside the home. They just claimed it was there. Taylor can get to the bottom of it, but the judge is standing in front of the prosecution, which is somewhat defending the prosecution, you see. So to go around the judge's defense of the prosecution, request that they provide the surveillance footage from the neighbor's camera. If the vehicle is not spotted entering and leaving the neighborhood, it's over. It will prove everything, and then the judge will have no choice but to accept the truth, that Koberger's DNA was used to frame him for the murders. Hopefully Taylor is working on this, because if not, arguing with the judge about the IGG process will potentially end up with a guilty verdict. Why? Well, for one, the judge will become impatient, and you don't want the judge agitated with evidence that has your client guilty of those murders. The judge would have a short fuse and gabble down upon Taylor, and Koberger would end up facing the death penalty. Remember, there are 4 victims in this case, and Taylor needs to be careful not to allow an image of defending a murderer manifest in this trial. That's what would happen if she doesn't attack immediately. Focusing predominantly on the DNA, Taylor would never establish that the DNA was not inside the home. Rather, the judge would come to the conclusion Taylor is stalling, focusing on how the prosecution obtained Koberger's DNA, which was inside the home. You understand? Hit the prosecution where it hurts directly by demanding they show evidence Koberger's vehicle was in the neighborhood. If they can't show this, then Koberger is innocent of those murders. But if you continue to attack the prosecution about the IGG process and claiming it should be thrown out, you're suggesting to the court that the judge rule the DNA itself to be thrown out as well. Because this is how they matched Koberger's DNA to the DNA in the home. In this context, Taylor sounds a bit absurd. But if she breaks down that the DNA was planted inside the home, then you go straight for the jugular. With the main evidence, yes, the main evidence, of no footage showing your client's vehicle in the neighborhood. Does everyone understand? Okay, we'll keep an eye on the hearings to see what happens. For now, we take a brief break. This is the Chaos Sector.